Oftentimes when the law becomes involved because of allegations of domestic abuse or domestic violence, people feel that that should be a private matter handled between the two of them. However, the law doesn't view it that way. The law views it as a crime of violence, and over the years, law enforcement has gauged their interdiction techniques and policies on the fact that domestic violence is going to be often a reoccurring problem, and they're addressing it as such. Even if it is an isolated incident, the two people involved in the relationship, the law doesn't have any way to know that, so they're going to prosecute anyone accused of domestic abuse or domestic violence as they would with any other type of case. When the police are called to a domestic violence situation and they make an arrest of some sort, if most often a husband is arrested for violence toward his wife or his girlfriend, they make that arrest, and the other person involved who was injured or touched in some way decides later that they don't want to pursue charges, they want to drop the charges. The policies in place in Illinois and in most jurisdictions are now that they don't have the ability to drop charges, that they are merely a witness in the case against their significant other, and the prosecution will proceed whether or not they want the prosecution to proceed. Their statements are on the record. They will be used against their significant other in trial and in prosecution. So people often make the mistake of thinking that they have the power to decide what the state does and doesn't do as far as those charges go. Normally, a domestic violence or domestic battery conviction is a misdemeanor offense. However, if there's a prior domestic violence on that person's record, or if there's serious injury or other factors that can come into play, it can be raised to a felony level. Once you have a conviction for a domestic battery case in Illinois, that is not something that can ever be sealed. It's not something that can ever be expunged from your record. Many people find that out only after the fact, sometimes 20 years after the fact, when they try to get an Illinois FOID card or otherwise own a firearm, only to find out that they cannot do that because of that domestic battery conviction from 10, 20 years ago or even last year. In addition, there's federal law that prohibits anyone convicted of domestic battery from owning a firearm as well. So the consequences are long-term and they are permanent. If you're convicted of domestic battery, that will be on your record for the rest of your life. There's nothing that can be done under the law as it stands now to clear your record or to get that erased or eliminated. So if a person already has a conviction for a domestic battery on their record as a misdemeanor, even if it's 20 years old, if they are arrested again for a new domestic battery charge, the state has the option of pursuing that as a felony charge. And a felony, by definition, carries the possibility of prison sentences as opposed to days in the local county jail or simply probation. So any subsequent offense, any new arrest needs to be handled very seriously because of the potential for felony conviction or felony record. And again, as I mentioned earlier, once that domestic battery is on your record, it will not leave. It will be on there forever. And obviously, most people would prefer to go through their life without being a convicted felon, and therefore that needs to be addressed seriously, immediately, and you should not wait to contact an attorney if there's been an arrest for domestic abuse or domestic battery within your household. So if you are convicted of a domestic battery, and that is permanently on your record, that will likely create problems in your future as far as passing any sort of background check. You'll have that domestic battery conviction, whether it's felony or misdemeanor, on your record for the rest of your life. So obviously, this is a very serious matter. It affects your rights. It has what we call collateral consequences. You'll not be able to own a gun. You'll not be able to touch a gun for the rest of your life in any legal sense. So obviously there are consequences that you may not be aware of in any criminal case, but specifically for domestic battery, those collateral consequences won't be told to you at court necessarily. The judge won't tell you you're never going to be able to own a firearm again. They won't tell you about other consequences on any particular case. They're just required to admonish you concerning your constitutional rights, and that's really the end of it. So you need an experienced attorney who focuses his practice on criminal law in order to make sure that you're protected. So if you have a loved one or a friend or family member that's been arrested for domestic battery, and whether or not they've ever been arrested for anything before in their entire life, you should contact an attorney as soon as possible after they're arrested to start making arrangements for protecting their rights and protecting their future. You can contact me at my office. I'm at 309-673-3939, and my office is located in downtown Peoria in the Commerce Bank Plaza. If you're not able to come in for an in-person visit, but you still want to have a conversation with me, I'll be happy to set up a phone conference with you as well. So call anytime. There's never any charge for a consultation.